Good afternoon. I am so pleased and honored to be here. I want to thank the Nibby Center, Mr. Joe Lagarde, Terry Janice, Amy, the whole staff, and audience members. I'm going to give you the most huge round of applause right now for being here, for participating, for all of those amazing questions that you have asked. I wish, and I'm so glad that you're doing the recording and that you're going to have further conversations, but I wish the message from this conference would get to every single region of our country right now. This is a critical turning point, as all of you know, or you wouldn't be here. And I'll just preface my own remarks by saying it takes a lot of time to actually get away from our busy schedules and to come together. And it takes a certain will to talk across our nations, our communities, our identities. And I just commend you for that willingness. If everybody in this country was able to do that, we would have such a different world. But that's a world that you want for your kids. That's a world you want for your grandkids, right? So let's just create it right now. Okay. So I am a law professor, as Terry said. I was the first executive director for the Indian Legal Program at ASU. And I did that job for 15 years, and that was in the latter part of the 90s into 2000, and that was a really turbulent time in Arizona politics because gaming was just getting up and running, and yet the Native American Graves Protection and Repatriation Act was being very contested. What were those rights to ancestors and cultural heritage items that were in the collections of agencies and museums? So what I did in those years is I always started my own trajectory with community meetings, always. What did the cultural leaders think? What did the community leaders think? What did the clans think? And that was different from tribe to tribe to tribe. Without that knowledge, I felt that you couldn't even implement a federal law. You had to go to the community. And I hope that that ethic comes back, because we are looking at some of the scariest issues that I have ever seen in my lifetime. And Terry and I had a conversation about artificial intelligence. He knows a whole lot about it. I'm learning. But what you can do with artificial intelligence is actually manipulate knowledge. You can manipulate understanding. You can have a picture that looks like something, but it's not that thing. You can have a voice that sounds like somebody, but it's not that person. And in that virtual reality, you can manipulate what people think, what they ought to think, and what their commitments are. And for Native people, I think the core to the survival, what we have here, is that people have never let themselves as a community go down that road, that they've always been able to reach back into the, to use fancy terms, epistemologies that formed the identity of the people from the beginning. That was the original creation, right? And we are so blessed to have those knowledge holders here. And I commend all of you that participate in that practice. That is what keeps things alive and living. And Professor Stark, that was the best presentation I have ever heard on traditional law. That was a classic. You have to give that at the federal bar? Can you give that at the federal bar? I'm gonna call those guys up. I'm gonna say, I see your agenda. That was awesome, awesome. So what I thought I would do, with your permission, I want to share some ideas with you about where we're at, what we're looking at, and how we can mobilize in the ways that all of you have been talking about. This is going to be more a conversation. You don't have to take notes. There's no PowerPoint.
I'm a lawyer. Just have it.
It's okay. You can take notes if there's anything meritorious. But I more want to I just want to connect with you about the things that I see. And I teach a bunch of things. I teach federal Indian law, but I also teach property law. Mr. Goldtooth, legend in our time, he has a lot to say about property law. I have to teach this to 1L law students. Do I believe in it? Not necessarily. Is it important? Yes. And what did I see with the real estate market and the leaseholds and things that were spinning up price-wise and the hedge funds and the da-da-da-da-da? Property governs a lot of what we have to deal with and always has. I teach American constitutional law, US constitutional law, powers, federalism. I teach individual rights and liberties, religious freedom, freedom of speech. So I'm taking that knowledge and I teach jurisprudence, the philosophy of the law, and I have to teach things like Locke and Hobbes, and then I bring in my own stuff. And I make the students say, well, we have a Commerce Clause, and the Commerce Clause mentions Indian tribes. What do you think that means? My students know what it means by the end of the semester. Nobody else teaches the Indian tribes part of the Commerce Clause. And that's why you get the opinions that are coming out from the United States Supreme Court right now about what they think the Constitution means in the context of relations with Indigenous nations. I have this rule on my Indian law exams and all my exams really, which is I don't deduct points. And I tell that to the students. I said, just do your best. Everything that you get right, check.
I would have loved to have heard that in law school. Or at least them telling us, be creative.
That's what I tell them, be creative. I say, the only time I'll ever deduct a point is if what you say makes me cry because it's so wrong. Like then I'll just think like you didn't even go to class. But I said, that's only happened twice in 20 plus years of teaching. Well, in 1 year, the Supreme Court has made me cry on more than one occasion because everything they're saying is so wrong. I'm working on water issues right now. That case that just came out dealing with Navajo Nation, the trust responsibility over water, it has the most ridiculous statements about tribal water rights, about trust responsibility, the most ridiculous statements, such as many people in the American public want to trust the United States. Does that give them any rights? No. Should Indians have any rights? No. Will the plenary power doctrine work just fine for them? And they're keeping everything they got by saying it was a trust. So if ever there was a time to change the intellectual dynamic, it's now. Because if they're not going to abide by the rules, then why should we? So with that in mind, I'll go through my points. And I only have 4 points. So it may not even take the whole time, but Terry's here to keep me honest. If it goes too long, he'll come and snatch the microphone and be all right. I trust him. I trust that man. He's an excellent colleague and a great alum. We are so proud of you, Terry. Okay, so the first thing I want to talk about is that relationship between what we framed as traditional law and this body of law that we're calling federal Indian law. That's been beneath the discussion since yesterday. Awesome opening panel. There was a question about ICWA. So it's embedded in people's consciousness, and I want to spell that out, and if you want to talk about it in Q&A, we'll talk about it. Then I want to talk about the tribal sovereignty doctrine in its fullness, which is a political component, and tribal political leaders are always busy. They have a ton of meetings, they have to go to this and that, there are all these consultations going on, so political leaders are always busy. The flip side of that is the cultural sovereignty. That actually exists even when a tribe doesn't have federal recognition. Native Hawaiian people have powerful cultural sovereignty. That has to be present every single day, and it has to be the priority. Otherwise, the political sovereignty means nothing. So I want to talk about that. The third thing I want to talk about is the role of what we're framing traditional law within institutions, and we've talked about 2 important ones. Tribal courts, and I'll pick up that theme. I am a tribal court judge at the appellate level too, and educational systems. There's so many of you that are embedded in educational systems in this room, and I really think that that is part of a continuum. I was talking to Kim last night. We were at the table after she did her amazing, beautiful prayer. Thank you, Kim, for opening. And we had this discussion about how that education from way back has to be there. And I mean from way back, right? It's in the teachings. And I was sharing with her that when I'm doing this work on water, I've been talking to the political leaders and their elders about the early parts of Arizona tribal water conflicts. And they remember all this stuff, but it's not written anywhere. And some of the people that were core in those early battles are no longer with us. And that's why the United States Supreme Court feels so entitled to write its silly opinion without any historical context or grounding. So I think that that's part of the education, to make that present so that they can't, and good for Minnesota getting that as a requirement in the public school system. We've been trying for years in Arizona. It hasn't happened, so that is awesome. And the final thing I'll talk about is that frame of human rights. And Mr. Goldtooth, let me know that he's on a call right now, but he'll be back. And he is instrumental in that process because that is the global dialogue. And there's a lot of energy in that global dialogue. And the caveat that I'll make is that in the United States, we tend to think of things in terms of like, is it binding on us? And the United States never signs on to binding protocols, ever, ever, ever. They'll sign on in principle, like, yeah, we're all for it, but they won't sign on in any binding way.
They need plausible deniability.
But we're not going to let them get away with that because we're going to be creative. So that's the thought that I'll leave you with, and then we can unpack that. Okay, does that sound like a plan? Okay, let's do it. So, in terms of the three frames of law that we've been talking about, Indigenous law / traditional law, federal Indian law, and then international human rights law, the foundation piece, the first pillar, is always going to be Indigenous law. Always. No question about it. And the instruction here, I want to take it back to this idea of traditional knowledge, and that's been floating through the conversation too. Traditional knowledge is tied to traditional law. The UN Declaration has a provision that talks about rights to cultural heritage. Tangible cultural heritage, sacred objects, for example, and intangible cultural heritage, the knowledge of. In this country, they want to put it into intellectual property law. Property framing. Is that permissible? Because there's Native people out there arguing that we ought to have intellectual property rights for our traditional knowledge because otherwise they're just going to come and take everything. I'm not going to ask you to answer anything publicly, but I want you to think about that. And I ask my students to think about that. How do we know what is permissible if we don't know what they're going to put it into, what that little box is, both the upside and the downside? And federal Indian law is that box. It'll do things maybe for you, like a right to consultation. If you're a federally recognized tribe and you have an interest, they'll do a right of consultation. That's good. That doesn't happen for non-recognized tribes, for example, in California. But is that the same as honoring the knowledge systems that tell us what the permissible actions are toward land, toward cultural items, toward ancestors? And it's not, right? It can never be that. It's antithetical. So we can't look at that box to frame what the positive content is of the traditional law. And the question of identity in law is very important so that we never get those things crossed up. We know what the traditional law is and says. And Professor Stark, I love that you talked about it as flexible and a continuum, especially among various bands or groupings of what is perceived as one people, but there are different understandings of the traditional law. And I see that all the time in cultural rights cases. There are different understandings with clans, with religious societies, and you have to be okay with that flexibility. That world is not okay with flexibility. You have the right or you don't have the right. And if you don't have the right, then they can take the value. So the idea of natural law and fundamental law was also attached to traditional law. The dominant society system, whether it's constitutional law, property law, Indian law, whatever the heck it is, the dominant society is always premised on a rationalist epistemology. It's secular, it's not religious, it has standards, principles, there are precedents, except for if you're in Indian law. Now the Supreme Court says there's no precedents either. But in everything else, there are precedents. And you reason by logic to get to a holding. Morality is not part of the dominant society's law. It is not. That is part of the natural rights tradition, which there's still philosophers writing about that, but they're religious philosophers writing, for example, from the Catholic tradition about why you should or shouldn't have a right to abortion, okay? So that's why it's discounted. Anytime you say it's natural law, people are like, religious, forget it, don't. And so that's the other thing to think about. When we're in that conversation with the other people, how do we want to talk about this? And I think that that's a conversation for each community to have, but those are the assumptions that they're going to make. Anything that's religious, it's not going to work for them. The other thing that happens with traditional law is that it's encompassing of a life way. And that's why when you were talking about the time that you tell the stories, for example, or what the obligations are to a particular, plant that you're harvesting, or when you harvest it, or whatever, that's an encompassing way of life. And they don't understand that. What they see is food as a commodity. Water is a rights-based use, and water is a commodity. They don't see the intricacies of the way of life. I think that probably isn't present in that body of law, not even federal Indian law. So where do we put that? Because that is the continuance of the people, the survival of the people. There has to be a way to frame that. Now, the rights of nature conversation became a way to think about that, right? Because if you were talking about the connection between land and people, which Professor Stark, that's what you were drawing out with such elaboration. If there's a way to, can we do like a graph or something? Because that was very powerful, how you talked about the complexity of it, but within that frame that people could attach to it. So what Mr. Goldtooth was saying is, when we're talking about rights of nature, we can't forget about the indigenous people. And then when Professor Stark was talking, he was saying, well, under Anishinaabe fundamental traditional law, that these are intertwined in such a way that it would be lunacy to deconstruct them, right? Because it's on that territory. The people are on that territory with that knowledge. And that, I think, is also what we can't let go of. Because you're right, the rights of nature in and of itself, if a tree has intrinsic value, and I think it does under indigenous views, right? Everything does have a moral, spiritual character that gives it a value that's distinctive and has to be respected. But some human society is going to have to adjudicate that. And if it's the rights of nature without indigenous people, it's going to be somebody saying, do we need open corridors for biodiversity? Yes. How about over this land? Okay, why not? That turns out to be the land that the mining company didn't want. But if the mining company did want it, then maybe it wouldn't have that value, right? Because then we'd have to balance the economics. We have to get out of that utilitarian balancing game, totally. And I think the different value constructions that you were drawing give us a frame to do that. So people and territory, I think that is the fundamental part. Now, the other part of federal Indian law, so it's sovereignty and property from the beginning, sovereignty and property. It's still about sovereignty and property. But the role of indigenous law was discounted at the date of colonization, because the doctrine of discovery, which applied to lands that were totally vacant, like some island in the ocean where there were just turtles, but it also applied to lands that were occupied by uncivilized non-Christian people. And the answer is why? Because they were racist? That's part of it. But the other part of it is that they were held to be legally vacant by the Pope and all of the European kingdoms and monarchs. They were legally vacant because they didn't have a law. It wasn't written. How do we know they had property rights? Therefore, they didn't have property rights. That is still embedded in US law as Aboriginal title. You have a right to occupancy, but you don't have a property right where if they take it by the Constitution, they have to pay you. They don't have to do that. Only if they say you have title, do you have title. And that's why the issue of the rights that were reserved for reservations, when reservations were created as permanent homelands, there is a federal reserved right that goes with that as of the date of creation. And the Supreme Court says, well, did they say it? Is it on there that it actually says you have this right to so many things in water and we're going to protect that? No. That is not how the reserved water rights. They applied the logic of discovery to the issue of trust-protected Indian water rights. And that is unacceptable. So the doctrine of discovery was the way that they took title to the land, but now federally recognized tribal governments have title to their land and their water, and they should have a trust-protected right to that until these cases are finally adjudicated. And the water cases in Arizona have been going on for over 20 years, and some of them go on for 50 years. What was it in Montana? It was some huge amount of time. So that's what we have to hold to. So Indigenous law was always present, and by framing that, by making it visible, you actually counter the mythology of the doctrine of discovery that said that these lands were legally vacant. They were not legally vacant, and that law is still present and in the knowledge and understanding. So that, I think, is a very important function of the law. Now, the second part of what I want to say, and I'll come back to these themes in a minute, but that right of self-determination, that really, it's in the Indian Self-Determination Act, but the US government isn't really big on self-determination, and that's why they really argued against that S in peoples in the UN Declaration. Because if you were an actual real people with a right to self-determination under the Covenant on Civil and Political Rights, which is the treaty under international law that says every people have a moral and political right to self-determination that other nations have to respect. They never were that, but then the declaration comes along in 2007 and says they are peoples with the same rights as every other people, including the right to self-determination, a right to autonomy over territory, over people, over resources, over self-governance, their own laws, their own institutions. It is all in that document. And yes, it is a normative, prescriptive document. It's not a treaty yet. It could be a treaty. It's on the same trajectory because before there were those UN civil political rights, that was the one, and then there's an economic social rights. Those were the two 1966 treaties. Basically, they were a declaration before that. Every provision that's in those treaties was a declaration before that, but people still had to hold to it. And that's what this one is saying. It's saying this is the law. It is inherent, it is intrinsic in the identity of these people. Nation states, do what you need to do to actually make that happen. Do we need an international treaty? No, because the framework of US law actually enables a willing United States government to sit down nation to nation with every federally recognized Indigenous nation and give life and content and meaning to the various provisions of the Declaration. That is embedded in that. It is a government-to-government relationship. And that's what ought to happen. Frankly, you can't wait for them to call for a consultation on, are they going to develop your sacred site? It's too late by then. You have to sit down early in the table and from a position of strength, negotiate over what is pivotal to retain, what is not even in the scope of argument. Because there are 46 articles in that declaration. Okay, so the second point is the sovereignty point, the difference between political and cultural sovereignty. So the United States Supreme Court and Congress are operating with the political construct of sovereignty, the domestic dependent nation in a trust relationship with the United States government, which has plenary power to modify tribal sovereignty, even to the point of complete defeasance. And that is a sentence out of United States versus Wheeler. They can eliminate, modify tribal sovereignty, even to the point of complete defeasance. Is that true? Absolutely not. Absolutely not. The United States government can do things under its US domestic law to take tribal land. It certainly has done that. It still can do that under its power of eminent domain and just pay some just compensation. It can take tribal water rights. It can't take away sovereignty. Sovereignty is built into, it's the core of who an indigenous nation is, and that is the cultural construction. The political construction says you're trustee, only now how can they say that with a straight face after the Navajo Nation? No, they can't even say that anymore. So, can the United States take away sovereignty from anybody? No. They have pre-existing sovereignty, so the United States cannot take away sovereignty. The United States can take away resources, can take away rights. And that really is a tragedy. That is a human rights tragedy if they do that. So the question for us in this room is what goes into cultural sovereignty? And I wrote an article many years ago with the then chairman of the Comanche Nation, we were both board members on NARF. And we wrote it in response to the Supreme Court's line of Oliphant, Montana, the whole implicit divestiture line of cases, which was also ridiculous. But we wrote about cultural sovereignty as being really informed only by the values and norms of the indigenous nation, which means that the nation has to understand its own laws. And that, I think, from the conversation about who should be present at the table when you have these discussions, the people that are representing the tribal nation in its legal sovereignty, both cultural and political, they have to be part of that conversation. And I think that it's just that question of what motivates them to take time away from this meeting or that meeting and come to this meeting. But that's the stakes here, because if you don't make that claim, then it's invisible to them. And this idea of how tribal sovereignty is limited, in last night's panel, Carrie gave a beautiful account of the Haudenosaunee and the clan mothers and the political dynamics there, where if a tribal leader in the traditional way, as I understand it, was acting out of the scope, they could just go ahead and remove it, and they had the authority to do that, and that way your leadership reflected what was going to be in the survival of the people. And Oren Lyons did come to ASU many years ago, and he gave an incredible lecture, and he talked about that concept of the 7 generations. And he said, our first duty, he says, for the political leaders is to make sure, and I'm just paraphrasing him, that the ceremonies and spiritual teachings are upheld. He said that's the first duty. And the second duty is to make sure that the people are cared for. And I thought that was very interesting, because he essentially was saying if you don't uphold the sacred, then you can't really care for the people in the way that they need to be cared for. So I think that is definitely built into that. So cultural sovereignty is not unlimited. That's another mythology of the Supreme Court. They think that if you let tribes have too much sovereignty, they're going to run amok and start doing crazy things, as if. But, it really is a limited notion internally about what's permissible. And those are the constraints on leadership. And the historical context is so important. I am so happy to be on these lands. I've never been here. They're so beautiful. And I'm learning, but I know that there's a deep history and set of relationships, and I'm very respectful of that. And everywhere I go, there's a different version of that. When I was in New Mexico talking to the Pueblo nations and their leaders, they have such a different history of water, different history of land, different history with Spain, Mexico, and then coming into the United States as citizens with land grants, and then the United States saying, but you're Indians, so we're going to treat you like wards. You know, and that's the historical context. So cultural sovereignty is understanding that context, understanding the traditional limitations on power and leadership. Where does power sit? And in the Pueblo Indian nations, there are powerful clan duties, religious societies, and responsibility, and that's intertwined in the governance in a way that this society couldn't do, but they do very well, and that keeps them where they need to be. So I think that is the promise of cultural sovereignty. I have one phrase in the article that I thought was important to share with you, and that we said cultural sovereignty is really a process of repatriation, a process of repatriating knowledge, cultural identity, heritage, cultural heritage and identity, land, and everything that is associated with that. And that is what I have seen happening, this whole idea of land back or stewardship of land, because the idea of self-determination supports not only the sovereignty model, but also the co-management of resources that under the jurisdiction of two sovereigns, the tribe and the federal government, or the state government, or more than one tribe. That's Bears Ears, right? They have a intertribal commission because it's the traditional land of more than one tribe. So all of that is possible here. So the, how am I doing on time, Terry?
Oh, you're good.
I'm good?
Yeah, you got 20 minutes.
Okay. So 2 more things to get into the institutional part of that. So cultural sovereignty, and I'll leave the citation to the article for anybody who wants to read it, because we really wrote that so that communities could have a discussion. And so there are lots of examples there of things that went well and went right and helped different communities pull together on some of these issues that were very contentious. So it was really intended for that. But the idea of institutional development was the follow-up to that education, your health systems, your court systems, all of those have been powerfully impacted by colonialism. And it was very important to do that, right? So with the tribal court systems, all of these functional, systems of justice that were in traditional tribal societies were actually removed, as were the traditional governments. And then Professor Stark talked about the CFR codes. Well, it became a federal administrative court. Those were the CFR courts. They could do things to people like hold them without due process that no Article 3 court could do. And they could do that because the CFR court was a federal instrumentality to civilize Indians. And the code looked like that. Everything that they thought was bad for Indians got put in as a crime or a civil offense. And everything that they wanted you to do was the incentive for the tribal equivalent. And that is how many tribal governments and institutions got co-opted by those frames, because there was a big reward for doing what they wanted you to do, and there was a huge punishment for doing what they didn't want you to do. Now, most tribes now, I think, have broken away from that structure, some earlier than others. But that is a good exercise for many tribal codes to see where are the residuals of those CFR, because you couldn't exercise jurisdiction over non-Indians under the CFR codes. It was really for Indians. And so under our modern principles of jurisprudence, we want to basically discount that and revise constitutions and codes according to what the values are. That's a conversation of cultural sovereignty. And the communities that have done that and come up with new constitutions have been much better off because their laws are integrated with their goals and objectives, unlike the former structure. So Professor Stark talked about the Navajo Nation courts by way of example. And I think that that is a good example because the traditional adjudicatory structure, which is framed as a quote unquote peacemaker process or court, still has the ideals of what the appropriate role of a person is who settles disputes, how they settle disputes. And that informs what the qualifications are for judges in the courts of the Navajo Nation as well, but it is a community-centered process with the peacemaker court. So it's a different way to achieve justice, but you could go to the district courts or family courts, and then of course they have the Navajo Nation Supreme Court. Their code is one of the most voluminous that you will see, and the conversation over codifying what is framed as the fundamental law was intense because the belief, much like the encompassing law that you talked about, Professor Stark, the belief is that the fundamental law is firm and it was given at the moment of creation, and therefore you have to do it right. And if you don't do it right, there's a tremendous consequence for not doing it right. So the wording that was used was very intentional so that people would understand what that meant. The application is sometimes hard. So in the cases of development of land, you know, there may be a conversation about whether or not some practice or development is inconsistent with the fundamental law, but at least it gets the conversation going at the community and governance level. So I do think that that is they got rid of their CFR court early in time in the 1950s, and they've been working on their court system ever since. So in terms of designing a contemporary tribal justice system, and that may be what there's a need for in some areas in the state. I'm totally not familiar with it, but I've worked with enough communities in different states to see that they're all the same challenges, but there's certain unique challenges that tribes have. So in California, PL 280, combined with that history of genocide and failure to recognize tribal communities, left these very small rancherias that don't have a lot of land. And sometimes they might have, 20 to 50 members, so they're relatively small. And so what sovereignty looks like there, or what a tribal court system looks like, is very hard because they don't have the infrastructure with every single tribe to have a full-on court structure. PL 280 was very damaging there because the state took jurisdiction over most civil and criminal actions for a long time, and the tribal courts really didn't develop. And so when you got into ICWA, then it was very hard to actually do these tribal court proceedings because they didn't have the tribal courts to actually the infrastructure to handle that. So they've been working very hard on that they have like 120 tribes in that state, maybe more. But there are many creative ways to combine resources judicially and meet the needs of the people. So I have to say that. Alaska is another, case where the failure to recognize Indian country there after ANCSA was catastrophic to tribal jurisdiction over territory in a meaningful sense. So we do have those challenges. But in a sense, just to summarize that message, the strength of paying close attention to traditional law right now is to correct the history, that has to be corrected, to make tribal law visible in its full form, which could be a civil family code that looks similar to some states, but it could be the traditional fundamental law of a nation. It is all of that, but it has to be visible to the external communities. The second important thing is that Indigenous law has a capacity to heal, and it has a capacity to transform. And that is the organic, flexible nature that Professor Stark, to my knowledge, that is not present in any of those other frameworks of law. This is a unique feature. And the final one are what I would call the points of intersection, which, you know, how can you go across tribes that have these really different cultures and languages and get some meaningful consensus about what traditional law means or should mean. And I went to a global Indigenous Law Conference many years ago. It was hosted in New Zealand, but there were people from Canada and from Australia, and it was so amazing. And the gentleman who was from one of the Indigenous peoples in Australia, I can't remember the name of his tribe, but he actually talked about one of their philosophies or prophecies that dealt with the constellations. And he was like, just like those points of the constellation that orient you, that's what we think about coming together as Indigenous people from the different geographies in the world, north, south, east, west, and everywhere that connects us. He said to identify those is to identify the path to the future. But they also had some interesting way in which they didn't look in a linear way. So like the 7 generations, they wouldn't be linear to them. They looked at it like a circle to where you were always going toward your ancestors as well as the future generations. So it was really a beautiful philosophy that he shared, and it stayed with me for a very long time. And I think that is the power of having these larger discussions. In the very last part of what I want to say to you is kind of this idea of the human rights framework. What potential does that have? And Justice Robert Yazzie, he was at that conference in New Zealand, and he was the former Chief Justice of the Navajo Nation. And he gave a really wonderful presentation there where he was talking about how hard it was for him as Chief Justice to look at the level of the disputes, and maybe it was framed in some sense in the earlier discussion we had today about internalized oppression, kind of the impact on families of trauma, but there can be these dysfunctions that he said, lead to things that we don't want, the loss of life and these terrible acts of violence among family and clan, even on the Navajo Nation. And he said, he viewed those as related to the earlier harms of colonialism, the fact that they discounted the idea of law and of traditional healing systems, the ceremonies that went into making a person understand who they were as a spiritual person connected to their community and to their land. And he said that the loss of hope was what he thought that they were witnessing. And he said that is a disease of the spirit. And so the work that I started after that conference was a project that I still have ongoing, where I'm looking at the idea of justice, which is different. It's different than law, right? I mean, there has to be some content to justice.
They sometimes meet, but not often.
Exactly. And that was my rude awakening in my first year of law school. I was all gung-ho, like, I'm going to do justice. And then nobody mentioned justice at all. I'm like,
yeah, justice tell you, shut up, be quiet. Why? Don't use that word in here.
Exactly. So I want to redirect that. And I want to say that's an overdue conversation for everybody in this room. And it seems as though we're always like fighting cases of injustice. Like I thought that case from the Supreme Court was one of the most unjust opinions I'd ever read. And it just made me ballistic. And then I was like, well, how do I even talk about this?
I was ready to rip up my Supreme Court, whatever, my bar card, everything. I'm mortified. How do you argue in court when the Supreme Court is like not based in reality, what we learned in law school?
Exactly. I felt the same way. And it's been appalling that Castro Huerta case, which was the jurisdiction case from last summer, where they basically obliterated half of the jurisdictional rules, but it didn't matter because he was a non-Indian and he was a bad person. So let's just get rid of jurisdiction for this guy. But I had that thought, that in both of those opinions, what the Supreme Court is saying is Indians are citizens. The state takes care of its citizens. They can trust the United States to do the right thing because we have a constitution. That actually is the bottom line of both of those opinions. And I'm here as a constitutional law professor to tell you that is BS. That is not true as a matter of constitutional law. It is not true. That is a mythology. And unless we call them on that, that is going to become our reality. And that is going to perpetuate the injustice. So it probably is a responsibility of every political leader and every tribal attorney or attorney who represents tribe. And there are many tribes who have big law firms in DC and Phoenix and, Denver, and that's their general counsel. So you have to get those people in the room too, because this just has to be called for what it is. So how do we address injustice? And injustice is weird because a lot of it is really epistemic injustice. And what I mean by that is that the categories that they make us argue, the reserved water right, the trust responsibility, they are categories that they made up, including a domestic dependent nation. They made that up as thin air.
They're fiction, so we need to turn it around. It's fiction. We're going to change it.
Exactly. Identify every fictional category and say, does that work for us today? And if the answer is no, then what do we need to do to correct that? And then my students start saying, but, federally recognized tribes they have certain, and we don't want the indigenous, but the South and the...
Is that what they sounded like?
And I have total respect for them. And this is what I say to them. I'm like, you are so right. There is, in a sense, a privilege that U.S. federally recognized Indian nations have globally. And at every conference I've been to, people say that. They'll say, it's not like that in our country. They don't recognize any sovereignty. In places like India, they say the whole country is indigenous people. There are no special rights for indigenous people. They're all indigenous. That's what they say in Africa. So if you're from a tribal community and you're really not getting your rights met, you can't go arguing under the UN Declaration because they'll be like, well, I'm indigenous too. Whole country is indigenous. And we've decided we're going to drill for oil. But that is not the case here. There are reservation lands. And beyond reservation lands, there are tribal territories. And the tribal territories, they'll say that they're not the reservation and therefore they're not native land, but that is false. The tribal territory is what Professor Stark said. That is controlled by the consciousness of the people over time to the very first time. And that is the most powerful connection that anyone can have to land. And that, I think, is what is happening. Carrie, I think you mentioned that about the Coast Salish people. When I was up there, it was very powerful because they don't let the US-Canada border stand in the way of who they are as a people on their territory. And in fact, they're making decisions about what that territory needs. And if the US wants to show up or Canada wants to show up, good. But they're going to be there making that law anyway. And they invite themselves to proceedings on either side of the border, regardless of whether they're recognized by that government. The Canadian ones come to the US hearings, the US ones go to the Canadian hearings, and they say, we're all Coast Salish and this is our territory. And that would be a more beneficial way to look at the connections. And I think that of the Colorado River too, and I'll just conclude there, but the Kokopah Nation is on both sides of the border. The Kokopahs on the United States side, federally recognized. They have a nice casino. They're doing relatively well. They got their water rights adjudicated way back in time. They're building, they're thriving. You go on the other side of the border, Mexico doesn't even know they're there. Their river is dead. That name for themselves means the people of the river. They can't even see their river anymore. They don't have any economic development. But they're still Kokopah. They speak the language. They have that love in their heart for that river and that land. And when you look at the pictures of that land before they went in with all those dams, it was beautiful. They remembered that. That's in their memory. So I say we take back all attention to colonial categories. It's nonsense. That is what is causing our epistemic forms of injustice, where we fit ourselves into boxes that harm us, and we call it out for what it is. Maybe it'll take a long time to fix things, I don't know. But if you call it out, at least you make it visible. And that was the lesson of colonialism. What was invisible, they took control. If it's visible, they have to engage it. You guys are beautiful. Thank you so much for allowing me to share those ideas.